All right, welcome, ladies and gentlemen. I'm excited that you're on today. We're going to be going through and talking about IRAs and, of course, how they relate to the Secure Act that was passed last year. Before we get started, let me just introduce myself. My name is Jeff Norris, and I am the lead advisor at Simplicity Wealth. Our office is located at 2100 Gateway Center, right by the airport, just off Aviation Parkway. This is promoted by Simplicity Wealth and Simplicity Group Holdings, and we are a full services financial firm located right here in Raleigh, but we have offices all over the United States. Now, me personally, I've been doing this quite a while. I've actually trained thousands of advisors all over the country. I've been referred to as the advisor to advisors. And I'm also a certified IRA distribution counselor. So I'm one of the guys that if people get in trouble with their IRAs, that I get called in to help get it straightened out and get things working properly. So today we're going to just cover three common mistakes or common traps that people fall into with their IRAs. And it's funny that these traps have to do also with the Secure Act. So some changes that were made to some of these traps that make it even a little bit harder to navigate as you prepare for retirement and work with your retirement accounts. So what are those three traps that we're going to talk about? Well, we'll get to them in just a second, but before we do, let me just tell you that I am not an attorney. I'm not a CPA. And some of the concepts that I'm going to cover with you today may require the services of one of those professionals. If you do not have a relationship already in place with one of those professionals, we have folks that we're happy to refer you to get you any help that you may need. So with that being said, let's talk about those three traps and the Secure Act. So what is the Secure Act? Well, the Secure Act stands for Setting Every Community Up for Retirement Enhancement. And there are some changes that were made to this. And when it came out, I knew some things were going to happen with the Secure Act and with retirement accounts. And especially one of the things that you may have heard about called a multi-generational or a stretch IRA went away. With the Secure Act. Now, once it passed Congress and it hit the Senate floor, Ted Cruz kind of debunked it and put it on the floor of the Senate, and it just sat there and sat there and sat there. Well, I knew it was coming through, and I knew that it would pass. And with that being said, it made a lot of changes, and a lot of advisors were calling me and asking me, you know, what are we going to do? How are we going to overcome this issue with not being able to do the multi-generational IRA or the stretch IRA? And so I actually held a webcast and had hundreds of advisors all over the country. And I shared with them 5 ways to continue to do the multi-generational IRA, 3 of which anybody can do, and 2 of which circumstances would have to be in place to do those. I'm not going to cover that today, but I am going to cover some of the changes with the Secure Act and where in the planning process that there's things that you need to consider and think about when it comes to your retirement accounts. Okay, so the 3 common traps are this. Number 1, having the wrong designated beneficiary of your retirement account, whether it's an IRA, 401k, 403b, 457, TSP, doesn't matter. Having the wrong designated beneficiary could mean excess tax to the. Number 2, having the wrong custodian, and we're going to talk about that. And number 3, after you retire, leaving your retirement account in your 401k, 403b, 457 TSP. We're going to talk about that as well. And as we go through each one of these, we're going to talk about how the Secure Act relates to each and every one of them. Okay. So number 1, the wrong designated beneficiary. Well, the Secure Act beneficiary changes were this. And here's one thing I want you to take a note of and make sure that you understand. In publication 590, okay, we have publication 590A, publication 590B. That is the IRS's rules surrounding retirement, or what we would call qualified assets. qualified retirement vehicles. And in publication 590, I want you to understand what it refers to as a beneficiary of a retirement account. Number one, it says that the beneficiary of that retirement account must be living and breathing. Okay, so it must be a live entity. So we'll get into that a little bit deeper. The other thing that it states about beneficiaries is that they must be named beneficiaries. You have to specifically name them as the beneficiary of the retirement account. And we'll talk about that a little bit deeper as well. So the Secure Act beneficiary changes are this. Number one, if you're a married couple, upon your death, your IRA can go to your spouse with no tax consequences. It's called a spousal rollover. Okay, that did not change when the Secure Act came through. But here's what did change. No inherited IRAs to non-spousal beneficiaries. So let's say you're a single person and you named your children as the beneficiaries of your retirement account. They can no longer take the asset and leave it in your name and continue the required minimum distributions based on their life expectancy. So there is no more non-spousal inherited IRA provisions with the Secure Act. The only exception to that is if you have a child or a dependent that is special needs. Then there are some opportunities where you can continue the distributions to a trust for special needs. So, if you have a special needs situation, it would be critical that maybe we sit down and have a conversation about that. The other thing about the beneficiaries, if you have a non-spousal beneficiary, is the distributions. Okay, so before you had three options, including the inherited IRA. Well, again, the inherited IRA went away. So the only distribution option that your beneficiaries have now is to take the distribution. So now they can take a lump sum distribution, which typically is not recommended because just remember that distribution is included in the income of the beneficiary. So let's say you have a $100,000 IRA and you pass away and your beneficiary takes it in a lump sum, that $100,000 is going to be included in their income on their next tax filing, which could catapult them into a higher tax bracket. All right. So the other option before the Secure Act was to take it out over 5 years or do the multi-generation or stretch IRA. Well, again, that's gone. So the distributions went from 5 years. They did increase it to 10 years. So your non-spousal beneficiaries, no matter how you have them named on your IRA, now have an option of taking two options. One of taking a lump sum. Number two, taking it out over a 10-year period, which is typically what I would recommend because we still have that. If we take it out over that 10-year period, we're controlling the tax much better than we would if we took it as a lump sum. Now, also having the wrong designated beneficiary, let's talk about wills and trusts. Okay, so a lot of people I see when I'm reviewing their IRAs will go in and they will name their will or their trust as the beneficiary of their IRA. Well, remember that I said that in publication 590, it says that your beneficiary must be named and it must be what? Living and breathing. Is a will or a trust living and breathing? No. So here's what I want you to pay attention to. So with a will or trust named as your beneficiary, upon your death, now pay attention to my terminology. Upon your death, your IRA, your retirement account, is distributed to that trust. That is a distribution. Wills and trusts are taxed as corporations. Now here's the other issue, is once it's distributed to that trust or that will, it does not change the designation of funds, meaning that the money inside that trust is still what? An IRA. So now it gets taxed as a distribution going to the trust. Now trust distributes it to the beneficiaries of that trust is taxed again as regular income. So the thing we have to remember is, why would we put an IRA? Why would we want to put an IRA in a will or a trust? Well, it would be to control the distribution, right? Well, here's the thing. A named beneficiary trumps everything else. So let's say you pass away and your estate goes to probate. Any account with a named beneficiary already bypasses probate. And that's one of the reasons you want to do a will or a trust, is to control the distribution and avoid probate. Well, you don't have to put any asset that you have physically named a beneficiary. You do not have to put that into a will or a trust. It's already designated. Matter of fact, if your will or trust does not match who you have named as your beneficiary, if it goes to court, that beneficiary trumps everything else. Doesn't matter what you have in your will or your trust. If that beneficiary's name, that asset's going to go to that beneficiary. So with a retirement account, we typically do not want to name a will or a trust as the beneficiary, because it means maximum taxation now and to your heirs. Here's the other issue that we find, is naming one beneficiary, only one beneficiary named. So understand that beneficiaries on retirement accounts, you can name as many as you want. So if you have a retirement account, what I recommend is building a beneficiary tree for any asset that you have beneficiaries on. So think about a tree. So the tree is little at the top and it gets bigger at the bottom. So if you have a spouse, typically your spouse is going to be your primary beneficiary. Don't stop there. Go ahead and name your contingent beneficiaries. Don't stop there. Go ahead and name your tertiary beneficiaries. Okay. And you can name as many beneficiaries as you want. They do not have to be family, just as long as they're named and they're living and breathing. The problem with naming only one beneficiary is, number one, you don't have any contingent if something were to happen to you and your spouse at the same time. If they're your primary beneficiary, you have no contingents named. Now you're leaving it up to the court system to decide what happens with that asset. Secondarily, you have no ability to disclaim. Now, what is disclaiming? If you guys understand disclaiming, when you get off here, you're going to know more than 90% of most advisors out there today. Disclaiming is a great planning tool. So what is disclaiming? Let's look at it. Oh, by the way, let me just mention this as well. If you name one beneficiary, you accidentally disinherit your grandchildren. And here's the other thing I want to mention is, make sure you check your accounts for your beneficiaries. Make sure it's who you want it to be. Believe it or not, so far this year, I have 3 times found where the broker has named themselves as the beneficiary of the IRA. Now, is that illegal? No, it's not. You can name anybody you want, right? Now, I can't think of why they would name themselves as the beneficiary. But there may be a purpose in it, but that is not kosher in my book. So make sure your beneficiaries are named and who you want them to be. So let's talk about disclaiming just a second. So this is what disclaiming is. Here I've got Jim and Wanda. Now, Jim has an IRA. He lives out through his life expectancy. At 72, he begins taking his required minimum distributions. Upon his death, even though he's been taking his distributions, the asset has continued to grow during that time period, and now it's worth $715,000. He passes away. Now that asset moves over to his wife, Wanda, who he has named as his primary beneficiary. Now, is that a taxable event? No. Remember, we said that it's a spousal rollover. There is no tax consequence in doing that. The only thing Wanda has to make sure of is, if she's over 72, that she takes enough required minimum distribution the following year to encompass all of the IRA assets that she has, including the one that she received from Jim. Now, let's say Wanda passes away. Now, she has named her son, Bill and Sue, as primary beneficiaries, but she didn't stop there. She went ahead and named the grandchildren as contingent beneficiaries. So what happens upon her death? The asset then is split into two accounts, one for Bill, one for Sue. Now, I want you to notice that Sue's daughter down here has a cap on. What do you think the next step in her life might be? How about college? She just graduated high school. Now college is in place. And let's say she needs $75,000 for college tuition. Well, disclaiming is this: as long as that grandchild is a named beneficiary, does not matter at what level, Sue can disclaim any portion of that $357,000 right on down to that grandchild. And guess what? Sue doesn't have to pay the tax. Now, somebody does, but who has to pay the tax? The granddaughter, right? But who's in a lower tax bracket, Sue or the granddaughter? What's the money being used for? Education. Now, you can ask most CPAs, but there's ways that you can deduct that tuition from the grandchild's taxes. So a lot of times we've done disclaiming. I've done disclaiming where it was not even a taxable event. So disclaiming is a great way to pass on assets and pass them on tax efficiently. Okay. So, and again, disclaiming, the only requirement is that whoever you disclaim it to must be a named beneficiary. You can't just disclaim it to anybody. They have to be named on there. So that's another reason why you do not want to name just one beneficiary. All right. So number two mistake is having the wrong custodian. Now, who's the custodian of your retirement account? It's whoever has the money. Okay. So if your retirement account is with TD Ameritrade, who's your custodian? TD Ameritrade. What if it's with Edward Jones? Edward Jones is your custodian. Now, what is the issue with possibly having the wrong custodian? Well, a lot of these custodians can't or won't do any distribution. So they require the asset to be set up completely separately. And a lot of them are not willing to set up that 10-year distribution for the client or for the beneficiary. Now, the other thing that comes into play too is once that distribution, you have to select or have to determine how you're going to take that distribution within 9 months of the death of the owner of that IRA. And you have to be able to take those assets either in a lump sum or over a 10-year period. And again, a lot of the custodians out there are not willing, we call it a willing custodian, willing to administer it over that 10-year period. So there's questions that you may want to look into. The other issue is that your custodians always aren't looking for safe avenues for those assets. And they're always out there saying, buy with that money. And a lot of times I find that people get into too much risk with that retirement account, which creates other issues that are out there. So what I'm saying here is that preservation may be that custodian or that advisor's main concern. Whereas I'm considered to be a preservation specialist when it comes to IRAs, and preserving the asset without sacrificing returns is a key part of what I do, okay, as an advisor. All right, number three, real quick, is when you retire, leaving your funds in your retirement account, leaving it in your 401k, 403b, 457, pensions, etc. Now, why is that an issue? Well, in publication 590, they refer to these programs as company-sponsored plans, company-sponsored plans. So who is in control? The company. The company is in control. So what happens is, and I found this to be the case in many instances where I've had some clients that have retired and had 401k or retirement assets and company sponsored plans, and they want to move it out. And here's what we want to do with these plans is move them out of the company sponsored plan into what is referred to as a self-directed IRA, a self-directed IRA. Who's in control of that? Self. Okay. We like self much better. And, you know, the other thing about having a self-directed IRA is the world is open to you as to what you invest in. Whereas most 401ks and 403bs and TSPs, you're very limited on what your investment options are. And you are at the mercy of the administrator of that company sponsored plan. And so in cases that I've had assets that were moving into a self-directed IRA, we have opened up the account, sent in the transfer paperwork. And I had one recently where the administrator of the 401k for the company had changed from T. Rowe Price to Raymond James. And so when the paperwork got to T. Rowe Price says, well, we have the account, but there's no money in it. The money's been transferred over to Raymond James. So now we go over to Raymond James, and Raymond James says, yeah, we've got the account set up, but the funds are in transfer. It took 40 days before the asset could be transferred. Now, what if he needed access to that money and needed to take a withdrawal during that 40 days? There was an issue, right? So, again, you're not in control. When you leave that money with your company sponsored plan, your control was all with the administrator and with the company, and they can do whatever they want to do without asking your permission first, whether it be change custodians, change administrators, work from an in-house HR department to a subcontracted HR department, which I've had a lot of issues with that as well. So those are some of the reasons why you don't want to leave it in your company sponsor plan. Here's the other reason as well.
Jeff,
one word for you. Enron. I'm sorry.
We're at 2 minutes, including questions and answers.
We're at 2 minutes.
Yes.
Okay. All right. So that's going to end up the presentation. Matter of fact, this was my last slide here, other than offering and getting you guys to write down something just for you guys attending the expo. When it comes to your assets, you have two questions that you have. One is, how much risk can you afford to take, and how much risk are you willing to take? So with your presentation today, everyone will have access free to a program called Asset Lock. It protects your assets. You're able to log on, input all of your assets into it. Any asset that you want, you're in control. No one has access to it but yours. And you set up what you are willing to take, the risk you're willing to take, whether it be 10%, 15%. If the market pulls back, when do you want to be notified about it? And let's say we set it up at 10%, it's going to notify you when it comes down. So I'm going to click through this and give you the website right here. So to download the app, the link, you see it below. You can have it on your personal computer or your handheld device by signing up with one of these links here. So at the end of this, if you contact us here at Simplicity Wealth, this is our number, 919-851-0846, and extension 233 is where you would get help signing up for Asset Lock. Okay, so let's open it up for questions.
So you have one question in the chat asking, what if the IRA is a Roth?
IRA is a Roth? Great question. Because when we talk about assets and we talk about qualified and non-qualified assets are typically assets that have been put away after tax. Well, guess what a Roth is? It's an asset that's put away after tax, but it still falls underneath qualified assets, because here's a good way to understand qualified assets. Anytime the government dictates to you how you put money in, how you take money out, and there's guidelines about how much you can put in, so forth like that, then it's considered qualified. So a Roth IRA is considered a qualified asset. And in Eastern North Carolina, we call Roth IRAs more better accounts, more better. Why? Because it grows tax-free, you can access it tax-free, and it goes to your beneficiaries tax-free. The distributions are exactly the same. The Roth IRA, upon your death, does go to your beneficiary. They can take it as a lump sum tax-free, or they had the option of taking it out over a 10-year period, absolutely tax-free. But again, we want to name those beneficiaries. So remember, we want to have a primary, a contingent, and tertiary beneficiaries named, even on a Roth. That was a great question.
Okay.